Hello and welcome back to Business Law. This lecture we're going to be discussing partnerships. Last lecture we discussed sole proprietorships. Basically we're moving along the complexity chain. Sole proprietorships are really easy to set up. Partnerships are easy to set up, but there is a little bit more formality, which we'll get into briefly. So partnerships. Partnerships are also referred to as ordinary partnerships or general partnerships. But they all mean the same thing. And what do they mean? Well, you have two or more owners, two or more parties acting as co-owners. And we'll get into some detail about what exactly that means to act as a co-owner. That's an important thing. Um, partnership, Partnerships are governed by the Uniform Partnership Act. Now, the Uniform Partnership Act has basically been adopted in one form or another in all 50 states. And that's the law that you turn to when it comes to determining how to form a partnership and also how to govern a partnership. And it's a pretty popular, pretty useful law. So we're going to be talking a lot about the Uniform Partnership Act, um, as well as partnership agreements. We're going to talk about those as well during the course of this lecture. Now, one thing I should stress, the Uniform Partnership Act is state law. When it comes to business organizations generally, the law governing the formation of a business is governed by state law. Now, there are some federal laws on the books that govern business organizations, but mostly, primarily, it's a function of state law. So whether you're forming a corporation, you're forming a partnership, a limited partnership, or a limited liability company, which we'll discuss in the subsequent lectures, you look to state law. So Uniform Partnership Act, that's what governs partnerships. What does it say? Well, for one thing, a partnership, like as I said before, two or more parties acting as co-owners. Now, those two parties, under the Uniform Partnership Act and other law, they owe each individual partner. This is very important. Owes the partnership a fiduciary duty. What does that mean? That's a really important concept, fiduciary duty, because it's used in other areas of law as well. What that means is you're putting the interest of somebody else ahead of your own. As a matter of fact, the only interest you can consider when making a decision is the interest of that other party. So the partners owe the partnership a fiduciary duty. Every decision an individual partner makes has got to be with the best interest of the partnership in mind. Not the individual partner, the partnership. Very important, a fiduciary duty. Um, what are some of the advantages of a partnership? The first, it's relatively easier to raise money than a sole proprietor. What I mean by that is, suppose you have three partners, A, B, and C, and they want to raise some capital to expand the business. They could take on D as a partner. They could sell D a partnership share in the business. This way they can raise money. So that's one advantage of a partnership. Um, Another is that the partnership, um, uh, each individual partner, the profits from the partnership are reported on the individual partner's personal income tax. So they're not taxed twice. The profits are not taxed at the partnership level and then at the individual partner's level. It's only taxed once at the individual partner's level. So those are two advantages of it. One other thing about the UPA, just off the bat, that I want to mention, the Uniform Partnership Act, it has adopted the entity theory of partnerships. What does that mean? That means that the partnership itself is a distinct legal entity. It can enter into contracts, it could buy goods, it could buy services, it could lease property. It's the partnership that does it, not the individual partners. It's the partnership that does it. All right. Now, suppose you and a classmate of yours uh, enter into a business. Um, at what point are we going to determine that the two of you, or let's keep it consistent. Suppose you and two other classmates of yours decide to enter into a business. At what point are the three of you considered a partnership? Now, this is important. Why? Because at the moment you are considered a partnership, as I mentioned before, the Uniform Partnership Act governs your business. So this is important. What makes a partnership a partnership? Well, number one, uh, you have to have a voluntary association of two or more people. No one can be forced to be a partner. Number two, they have to be carrying on some kind of trade, profession, or business um, for number three, profit. Or at least the intent is to make a profit. As you know, many businesses don't make money right off the bat. So at least the intent has to be making a profit. It has to be making a profit. Number four, they have to be acting as co-owners. Now I mentioned that before. It's two or more people. What's a partnership? Two or more people acting as co-owners. What does it mean to be a co-owner? One, they share in the management responsibility of the business. And two, they share in the profits. So, for instance, suppose you and two of your classmates, A, B, and C, start a business. And it's no doubt you're a partnership. Everything is, you fulfill those four criteria. Things are going really well. You decide to hire an employee. That's fine. You hire an employee D, say employee D. Employee D is working out great. The three of you love D. She works hard, she's honest, she's diligent, she really brings a lot of value to the company. As a matter of fact, you give her, the three of you give her a lot of management responsibility. Does that mean she has become a partner? Well, let's go through it. Being a co-owner means what? Sharing in the management, correct. But then how is she compensated? She's compensated through wages. She has a salary. She doesn't share in the profits. So although she has a lot of management responsibilities, in fact, she is not a a partner. Okay. Now, what about, suppose it's determined you're a partnership. What about your name? Well, like a sole proprietorship, you could use the name of any individual partner or any combination of individual partners. That could be your name. But again, suppose you want a name that better reflects your brand. Well, just like a sole proprietorship, you can go down and file a fictitious business name certificate. A fictitious business name certificate, a doing business as. Go down to the county clerk's office, just like you would a sole proprietorship. You fill out the form, you pay your fee, and you have a DBA, a doing business as. Great. Again, there might be a publishing requirement, depending upon your state, that you have to take out an ad and legal notices or something like that. But that's fine. That's fine. All right. Now, what about? We talked about briefly some of the advantages of a partnership. Number one, you can raise money, and number two, um, 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 the income, the profits are reported directly on the individual partner's income tax. But what might be some of the disadvantages? Well, probably the biggest one is that, like a sole proprietorship, each individual partner has unlimited personal liability for any losses or debts incurred by the partnership. So the creditors, they can go after any or all of the partners for the money that is owed to the creditor by virtue of the partnership. So that's probably the biggest disadvantage. Another two disadvantages, well, the UPA, it's related to the entity theory. The UPA adopted the entity theory of partnerships. Again, a partnership is a distinct legal entity. So what does that mean in terms, for instance, again, you have A, B, and C, the three of you, you graduate school, you're in business. Um, A commits a tort during the course of partnership business. Could B and C potentially be liable for A's tort? Absolutely. So that's a potential disadvantage of a partnership. That's referred to as joint and several liability. So if A commits a tort during the course of partnership business, that could be a problem for B and C. The plaintiff will sue A individually and the partnership, but also the plaintiff can also sue B and C and potentially collect against B or C if the partnership can't pay it off or if A can't pay it off. So B and C obviously are not going to be very happy about it. That's joint and several liability. That's kind of a disadvantage of partnerships, but it's part of the nature of partnerships. Another kind of similar to torts, again, we have A, B, and C acting as partners. Well, what if A signs a contract? Are B and C bound by the terms of those contracts as well? Absolutely. B and C are bound by the terms of that contract. So in terms of disadvantages of a partnership, well, one, you have the unlimited personal liability of each partner. Then you have joint and several liability for any torts committed by any individual partner, and also joint and several liability for any contract signed by any partner. As a matter of fact, unless you say otherwise, any partner can sign a contract on behalf of the partnership, and it is in fact legally binding. All right, now let's talk about partnerships. You have um, uh, uh, this is a pretty common scenario. I want to use this as an example. Suppose you have two people, right? Um, A and B. A is a graduate of the Culinary Institute of America, a premier restaurant school. A is young, uh, smart, has a lot of knowledge and intelligence about the restaurant industry. But what does A lack? Well, like most young people, they usually lack money. But A would like to start a restaurant. They have the knowledge and the expertise, they just don't have the money. Now you have B. B comes along and B is older, successful, and has money. And one of B's dreams has always been to what? Own a restaurant. So A and B find each other and they say, this could be a great partnership. B says to A, you'll provide the intellectual capital, if you will, set the menu, hire the wait staff, the chefs, design the restaurant, and I'll be the financial guy. I'll provide the financing and take care of the books. So B provides 99% of the capital contribution, the monetary capital contribution, 99% of the money. A provides 1%. All right. What about the right to manage? The right to manage the partnership. Does B have the right to manage 99% of the partnership? Well, we're going to talk about partnership agreements shortly. Unless we have a partnership agreement, we go to where? The Uniform Partnership Act. And the Uniform Partnership Act says, among other things, that regardless of the capital contribution of each partner has an equal right to manage and conduct the business of the partnership. I mean, B might be comfortable with it, but still, B has put up 99% of the monetary capital. So just keep that in mind. What about with respect to profits? Here again, B has put up 99% of the money. Are they entitled to 99% of the profits? Well, again, in the absence of a partnership agreement, what would you do? You look to the Uniform Partnership Act. And the Uniform Partnership Act says, once again, regardless of capital contribution, each partner has an equal right to a share of the profits. So the profits are split 50-50, regardless of capital contribution of A or B. What about with respect to voting rights or conflict resolution? Um, when you have a situation where B, they contribute 99% of the monetary capital, um, do they have 99% of the voting rights? No. As you probably figured out, the Uniform Partnership Act says that regardless of the monetary capital contribution of each partner has equal voting rights. All right. Well, I mean, that may work well. You might be comfortable with that. Maybe in our situation, it kind of makes sense. Because after all, B doesn't even know how to boil a pot of water, much less run a restaurant and set a menu. So B really needs A in that situation. So that might work. That just might work. But what if we don't have that kind of situation? What if we have, B is a different type of situation? A and B, may want to enter into a partnership agreement. So basically, the Uniform Partnership Act will act as your partnership agreement in the absence of an individual partnership agreement. So you can agree to have an agreement separate and apart from the Uniform Partnership Act. That's fine. So what is a partnership agreement? It's basically the contract between all the partners. It's the governing document of all of the partnership. Now, what should be in a partnership agreement? Well, we kind of mentioned a couple of things before. One, the capital contribution of each partner, past, present, and future. Now, that includes money, obviously, but it also includes things like goods, services, and time. So that should be spelled out. Capital contribution of each partner. The name of the partnership and its purpose. That should also be put in the partnership agreement. And why not? When it comes to the purpose, though, of a partnership agreement, I'm sorry, my daughter's cat is just walking by. I want to make sure she made it. When it comes to the purpose of a partnership or any business, I like to be as broad as possible. Why? Well, suppose, for instance, again, we have A, B, and C. They enter into a partnership, and they state in their partnership agreement, the purpose of this partnership is to sell cheeseburgers. Great. No problem. Business is going well. B and C decide, you know what? Business would be better, would be even better if we could sell hot dogs. A says, I don't want to sell hot dogs. B and C says, well, it makes all the sense in the world. A can say, too bad, so sad. The partnership agreement says what? The purpose of this partnership is to what? Sell cheeseburgers. So out of luck. So the type of language I like to use is something like any lawful purpose under the laws of New York State and the United States, or something like that. I like to keep it as broad as possible. And that's probably a good idea rather than narrow. It kind of helps avoid issues in a sense. All right, so the nature and purpose of the partnership, the capital contribution of each partner, also the profit and loss allocation. How are the profits and the losses going to be divided between the partners? That's up to negotiation. You can decide anything you want. The authority of each partner. Which partner or partners will run what aspects of the business? And the example we gave before of A and B opening up a restaurant, A is the graduate from Culinary Institute of America. It may make more sense that what? A do things like set the menu, design the restaurant, hire the wait staff, the chefs, the bartenders, stuff like that. And B, it may make more sense that B do what? More of the financial things. Take care of the banking. Make sure that the vendors are paid. Make sure that the employees are paid. The utilities are paid so the lights stay on. Stuff like that. But you may want to spell that out in the partnership agreement. Why not? Excuse me. It's probably a good idea. What else should be in the partnership agreement? Well, what about this scenario? You have A, B, and C. The three of you graduated school together, and you're in a partnership. Now, A has a younger brother, and that younger brother really isn't too bright. D, all right, we'll call him D. D has graduated college and cannot find a job for anything. But D approaches A and says, what? Why don't you make me a partner in your business? Older brother, older sister. And A thinks, well, he's my brother. It'd be nice. B and C, of course, are what? Saying to themselves, no way. D is an idiot. I don't want D as a partner. They're going to screw everything up. Well, another thing to do is to determine how to admit new partners, how to bring on new partners. So when you have a small partnership, I would think that the decision to admit a new partner, that should be unanimous. You really should, if there's only 3 partners, I think, it's got to be 100%. But maybe if the partnership, like some law firms can have a couple of hundred partners, and believe me, it's tough to get a couple of hundred attorneys to agree on anything. Maybe, a simple majority is enough to admit a new partner. But that's up to negotiations, of course. So how to admit a new partner. And also, how is that new partner going to buy in? At what cost? So that should be addressed, how to admit new partners. Kind of the flip side of that, again, suppose you have A, B, and C, the 3 of you graduate college, you open up a business, you're a partnership, and it's going really well, but C wants out. C wants out. Not for any personal reasons or anything, just that, the business is going well, but I want to do other things with my life. Maybe I want to start a new business, maybe I want to travel, whatever the case may be. C wants out. How to buy out a partner. Very important. How do you buy out a partner? We'll talk about that later, because if you don't address those things, like how to buy out a partner, then you have to bring a motion to dissolve. And that becomes a little bit tricky. We'll talk about that towards the end of the lecture. So how to buy out a partner, very important. Which partner will have signatory authority at the bank? That's also another big question. Who can sign on behalf of the bank, or I'm sorry, of the partnership? Who has contractual authority? Who has the right to sign contracts on behalf of the partnership? I mentioned before that any partner can sign a contract on behalf of the partnership, but is that really a good idea? In the situation we had before, A and B, B was the money partner, maybe only B should have that right to sign a contract. Maybe it makes more sense. In any event, usually just having one partner is easier. Well, I mentioned before that there is joint and several tort liability for torts committed by one partner in the course of partnership business. So again, we have A, B, and C. A commits a tort. B and C are potentially on the hook. If B and C have to pay, they're obviously what? Not going to be very happy. Now, you can't change that in a partnership agreement, but what you can do is you could put in an indemnification clause, I-N-D-E-M-I-N-F-Y, indemnification clause. What that means, indemnification simply means this. It's when one party agrees to pay the legal debts and obligations of another party. So, in the situation I described before, A commits a tort, but the plaintiff collects against B and C. If there's an indemnification clause in the partnership agreement, B and C can collect the money they pay to the plaintiff from A. So you can put that in the partnership agreement as well. That could be important. Another thing that should be addressed if a partner dies. Well, normally when a partner dies, the partnership dies with it. But you can have a continuation agreement included in the partnership agreement. That's not a problem. You can have a continuation agreement. Kind of related to that, insurance. Partners bring economic value to a partnership. So if one partner dies, that partnership is going to suffer financially. So maybe the partnership will take out a life insurance policy on each individual partner. Why not? It could also help in terms of determining inheritability. So insurance, that should also be addressed. Um, Another thing that should be addressed in partnership agreements, dispute resolution. I mean, you have, in our example, we have A, B, and C. Disputes happen in any partnership. Um, what if there is a real dispute? Well, one, if you're going to vote on it, what kind of voting requirements are necessary? Does it have to be 100%? In our example with three partners, does it have to be 2/3? Maybe it depends on the issue. So the voting requirements to resolve a dispute. Or perhaps you could put in an arbitration or mediation clause. Remember arbitration and mediation? Very important, very common in business. You will encounter them in your life, I guarantee you. So you could put in an arbitration and mediation clause where if there are any disputes between the partners, it's submitted to arbitration, it's submitted to mediation, or whatever the case may be, whatever you agree upon. So those are just some of the things that can be addressed in a partnership agreement. The list is by no means exhaustive, but a good starting point, I think. All right. Well, when does a partnership end? A partnership ends when one of the partners decides they no longer want to be a partner. Why? Well, what was the first criteria of partnership? It's a voluntary association of two or more people. No one can be forced to be a partner. So the moment that partner decides they don't want to be a partner anymore, it's over. It's over. The partnership is over. Now, hopefully, you've addressed that in your partnership agreement. How to buy out a partner, for instance. How do you buy out a partner? Great. I don't want to be a partner anymore. Buy me out. All right. What does the partnership agreement say? That's the end of it. But what if you don't have a partnership agreement, or you have a partnership agreement but you don't address that? And that's something I want to just kind of do a little important outlier. When people enter into business, they're very optimistic, and they should be. But sometimes you have to think, what if things do go wrong? How is it going to end? And hopefully it ends nicely, or at least in a way that everyone agrees upon. So that should be addressed in the partnership agreement. But suppose, again, your partnership agreement, it doesn't address buying out a partner. It doesn't address ending the partnership. What do you have to do? Well, the partnership has assets. So you have A, B, and C. A wants out. A wants out of the partnership. That's fine. How is A going to do that? Well, if they can't agree, if A can't agree with B and C how to get out, A has to bring a motion to dissolve in court. A has to commence litigation, bring a motion to dissolve. A motion to dissolve the partnership. Now, it's not really dissolving the partnership. It's really dissolving the assets, dividing the assets, if you will. Why? Because the partnership is over when? The moment that motion to dissolve is filed. Not when it's decided by the court, when it's filed. Why? Because no one can be forced to be a partner. Now, this is important. I want you to keep track of that. The partnership is over the moment the motion to dissolve is filed. Motion to dissolve, basically what, in our example, A is telling the court, the partnership is over, we need you to divide the assets. We can't agree. Fine. You file a motion to dissolve. A files a motion to dissolve, but B and C, they continue the partnership business. Now, B and C continue to sign contracts. B and C continue to deal with vendors and suppliers and customers. They continue to deal with D, E, and F, people that they've dealt with all along. Now, do D, E, and F necessarily know that A is no longer a partner with A, B, and C? Do D, E, and F necessarily know that? No, not necessarily. And what did I say at the very beginning? When it comes to signing contracts, regardless of who has authority to sign the contracts, that contract is binding on all the partners. D, E, and F, they don't necessarily know that A has filed a motion to dissolve. They don't necessarily know that A is no longer in partnership with B and C. B and C have what is known as apparent authority to act on A's behalf. B and C have apparent authority to sign a contract and still bind A to that contract, so that if D, E, or F have a problem with that contract, they can sue not only the partnership, not only C and B, but also A. Well, that's obviously a problem for A. So what should A do? What should A do to protect herself from this apparent authority? Well, one thing A can do is send a copy of the motion to dissolve to D, E, and F. Just send a copy of it to them with a cover letter. Pursuant to the enclosed motion to dissolve, I am no longer a partner I am no longer in partnership with B and C. Now what? D, E, and F, they know that A is not a partner. A can also take out an ad and legal notices. Not that anyone reads the legal notices. I don't. I'm an attorney. Well, I shouldn't say that. Sometimes I do. But by taking out an ad and legal notices, you're putting the world on constructive notice that you, A, are no longer in partnership with B and C. Now, the book goes on and discusses some other steps that a withdrawing partner can do. For instance, canceling any licenses, permits, or certifications in the partnership's name. Well, let's think about that. You'd have to do that before you file the motion to dissolve. But before you file the motion to dissolve, you're still a partner. And you owe the partnership a fiduciary duty to act in the partnership's best interest. Is canceling licenses, permits, or certifications belonging to the partnership acting in their best interest? Absolutely not. Potentially, you could be sued for breach of fiduciary duty. Very serious cause of action. Another thing, cancel or change checking accounts. Well, if you do that, if you cancel a checking account, are B and C going to be really happy? No. Again, if A did that, would A be acting in the best interest of the partnership? Absolutely not. Again, that's breach of fiduciary duty. Canceling any DBAs, doing business as, or withdrawing them. That's a problem as well. That's not acting in the best interest of the partnership. So my advice is not to do those things because you could potentially be sued for breach of fiduciary duty. But I think you can accomplish the same thing simply by taking on an ad and legal notices. That you filed a motion to dissolve. It's going to be heard by this court on this day. That's fine. And also by sending all the third parties the partnership has dealt with, customers, vendors, suppliers, a copy of the motion to dissolve, or at the very least a letter indicating I have filed a motion to dissolve. I am no longer partners with B and C in our example. So that's just how I would handle that. But partnerships, great form. Now, what goes in partnership agreements, you got to know that. That's just good stuff to know. All right, I just want to touch briefly on limited partnerships, and then the next lecture I'll go into more detail. Just briefly, a limited partnership, again, there are two or more partners, but the difference between a general partnership, ordinary partnership, and a limited partnership is that with a limited partnership, you have at least one regular or general partner and one limited partner. With an ordinary partnership, With a general partnership, everyone is a general partner. Everyone has the right to manage the business. So what's the difference between a general partner and a limited partner? Well, both contribute capital, uh, whether it be monetary capital or intellectual capital or services or goods, whatever the case may be. Both contribute capital. A general partner has a right to manage the partnership, whether it's a general partnership or a limited partnership. A limited partner doesn't have a right to manage the limited partnership. The only right a limited partner has is the right to vote. That's it. So why would someone want to be a limited partner? Well, a general partner has unlimited personal liability for any debts incurred by the partnership. A limited partner, their liability is what? Is limited to their capital contribution. So with that, I'm going to end this lecture. Next lecture, we'll pick up on limited partnerships and limited liability companies and finish off with corporations. And that's it. So take good notes.